Good morning, everyone. We're going to get started. My name is Seth Piccirillo, Director of Economic Development at the Buffalo Niagara Partnership. Thank you for starting your morning with the BNP. Over the past 19 months of the COVID-19 pandemic, the BNP has focused on getting our members and the entire Western New York community the most current updates and useful resources to keep your workforces safe and our economy moving. That commitment continues today as our region and country deal with an increase in Delta variant infections, and as we discuss President Joe Biden's September 9th COVID-19 action plan announcement. As part of that action plan, President Biden has stated that all employers with 100 or more employees must ensure that their workers are vaccinated or tested weekly. So that's going to be today's focus, but that announcement also includes requiring vaccinations for all federal workers, for contractors that do business with the federal government. Next slide, please. Thank you. Requiring COVID-19 vaccinations for over 17 million healthcare workers at Medicare and Medicaid participating hospitals and other healthcare settings. Calling on large entertainment venues to require proof of vaccinations or testing for entry, and requiring employers to provide paid time off to get vaccinated. Currently, the United States Department of Labor's Occupational Safe and Healthy Administration, OSHA, is developing a rule that will specify the requirements meant to ensure that the employers with 100 plus employees are fully vaccinated, or require any remaining workers that are unvaccinated to produce a negative test result on at least a weekly basis before coming to work. OSHA will issue an emergency temporary standard, or an ETS, to implement this requirement that will ultimately impact over 80 million workers in private sector businesses. With that ETS not yet released, Buffalo Niagara employers are left with a lot of gray area and many questions, and collectively, we do not want to wait until after the release of the ETS to create a plan for our workplaces. So today, the BNP is welcoming Jose Santiago, General Counsel and HR Compliance Officer for Alcott HR, to discuss what we know about this announcement, who it will apply to and who it may not apply to, and the best ways for companies to prepare for the release of this rule. Alcott HR is a human resources company with over 30 years of experience and is verified as a professional employment organization by the IRS, offering a wide range of services to its clients. As General Counsel and HR Compliance Officer, Jose is responsible for all legal matters at Alcott, including ensuring compliance with labor law, defending contractual IP and labor rights, and educating colleagues in the management team of legal risks and opportunities, which makes Jose the perfect person to talk about this OSHA rule that's upcoming and how we can navigate it. After Jose gives his remarks, we are going to leave a good amount of time for question and answer. You're going to see a Q&A button at the bottom of your screen. Please type your questions there, and if you see a question that you like already asked, please upvote it so it can get to the top of the list. We have a large group today, so we can only answer questions that are posed by an actual individual. So please, no anonymous questions. You'll see a name field that you can enter your information to. And if we don't get your questions answered today, our team will follow up via an email. So before we get to Jose, let's point out the existing resources that are available to you and that will help you stay up to date with these new requirements, create a vaccination plan, and communicate it to your employees and customers. We encourage everyone to visit the COVID-19 resources and impact page at thepartnership.org. There you're going to find COVID-19 related updates, legal best practices, HR resources, financial assistance programs, and all the information that the BNP team has been building over the last 19 months. You're also going to see the BizLink option. So if you have a specific question for your company, you can click on the icon that you see here, the business link on our homepage as well. We will answer your question, and if we can't do it in-house, we will reach out to a network of experts and get your question answered as soon as possible. There's a few specific features of the BNP COVID-19 resource and impact page that are critically important as the OSHA rule is upcoming. You're going to need to connect to testing and vaccine access. So what we've done on this page, about halfway down on the resources page under the testing option, you're going to see everywhere that you can test and direct employees in the region. Further, you're going to see the vaccine access tab that'll show you everywhere that you can direct employees, whether that be state run or not, next slide, please, that you can direct your employees to where they can go get the vaccine. Then also, there's the communication tab where you can see how you can communicate your testing and vaccination plan to your employees and customers, pulling from information from national experts and health organizations. Our COVID-19 resource and impact page also includes recorded webisodes that we did a few months back for a 3-part series, preparing your business for COVID-19 vaccines. We did this in April of this year. Highly recommend taking a look at this. We know that people trust information about vaccines more when they're delivered by their employer, just as we know that COVID-19 vaccines save lives and can return us to a greater sense of normalcy in this community and will allow the Buffalo Niagara economy to fully reopen. The 3-part series breaks down how employers can create a clear vaccine policy for employees, temporary contractors, their customers, reduce barriers and make it easier for them to get vaccinated when it's their turn. There's a lot of good boilerplate documents, emails, communications that we highly recommend that you take a look at. So with that, we're going to hand things over to Jose Santiago from Alcott HR to talk a little bit about what we currently know and what we can expect in the OSHA ruling. Jose, thanks so much for joining us today.
Good morning, Seth. Thank you everyone for inviting us to participate today in this webinar. We always appreciate our partnership with the partnership. So just before I get going, I'd be remiss if you go to the next slide. If I didn't first obviously state that the information that we're going to discuss today, it's intended to provide general best practices and employment guidance to the partnership. By Alcott HR, we do not run the legal advice, and the content of this presentation doesn't constitute the provision of legal counsel. I'd be remiss if I didn't start off with that. So that being said, we can go to the next slide. And first and foremost, what I wanted to do today is first just give everyone kind of the lay of the land. What's the landscape right now with regards to where any potential litigation is with regards to the vaccine mandate by the Biden administration. So you may be aware that just recently, the state of Arizona, the Attorney General did file a lawsuit against the Biden administration, asking the court to not only declare the mandate itself unconstitutional, and we're not going to get into the argument as to why, but just wanted to point out that this litigation is pending, and asking the court to issue a preliminary injunction. Now, what that basically means, when you ask the court to issue a preliminary injunction, you're asking the court to basically hit the pause button on this legislation, or excuse me, on this executive order, until the parties have had an opportunity to present their arguments to the court. The argument is that if you don't issue this injunction, then it could lead to undue harm to many people that would be forced to become vaccinated if this pause button is pressed, if a preliminary injunction isn't issued. Secondly, there are also 2 other matters pending in the states of Michigan and in California against 2 state universities, where the plaintiffs in those cases are employees of the university that are arguing that the mandates are also unconstitutional, but the arguments are a little different. Interestingly, the argument has to do with this mandate not taking into account the fact that there are many people that are immune at this point because they've already contracted COVID. And the argument is that they shouldn't have to get vaccinated and they should be given the option to opt out of the vaccine mandate. So that's the argument that's currently pending in front of those jurisdictions, which we kind of foresee we're probably going to see similar litigation elsewhere throughout the country and other arguments being put forth as well. So again, the reason I bring this up is because although we do have to do, as employers, as business owners, we want to make sure that we're prepared. We want to make sure that we have all our I's dotted, T's crossed in anticipation of having to comply with the ETS once it's released and this vaccine mandate. But at the same time, just to let you know that there is a chance that this might kind of get paused while this litigation is resolved. So I just want to put that out there at the beginning before we get into some of the questions that we've seen being asked by many employers. All right, we could go to the next slide. All right, so some of the questions that we have, and again, this is always better when it's interactive. So I listed a few questions here that I'm going to go over, but then, hopefully we'll have time for the membership to and for the attendees to ask questions, because that's usually the best way to move forward with these webinars. So first and foremost, when can we realistically expect OSHA to issue the ETS, the new rule? When is it going to be announced and implemented? Well, as I mentioned earlier, we don't know yet when it's going to officially be released. The anticipation was that within 30 to 60 days of Biden issuing the executive order, that an ETS should be released by OSHA. However, at this point, even if OSHA does release its emergency temporary standards, its ETS, there's a chance that that rule may be stayed, as I mentioned earlier. So that's one of the questions that we receive. It's also expected that employees will have substantial time, assuming that the ETS is issued and must be complied with within the 30 to 60 days as anticipated. Then employees are expected to have 75 days, more or less, from the day that the executive order was issued in order to become vaccinated, or at least obtain the first dosage. So that's kind of what we're expecting. Another question we're receiving is, well, what exactly constitutes 100 employees? How are they calculating this? What we're anticipating, although they have not issued an actual definition of what's going to constitute an employee for purposes of assessing whether or not the employer is required to comply. Our anticipation is that part-time versus full-time is not going to matter. A part-time employee is considered one employee. A full-time employee is considered one employee for purposes of whether or not you're reaching the 100 employee threshold. Remote employees, our anticipation is that they will also be included towards the 100. It's a different question that we'll get to, whether or not a remote employee needs to be vaccinated. We'll talk about that in a second, but they will be counted, at least that's our anticipation, towards the 100. Is it per location or is it collectively? It's our anticipation is that OSHA will use what's called the enterprise rule, meaning that all of your employees, regardless of where they're located, if they're a part of your enterprise, whether it's one location or 20 locations, will be counted together towards the 100 employees. Another caveat to keep in mind is that sometimes you have businesses that may be under different EINs, or you believe them to be independent, but maybe they're part of a bigger conglomerate or company that is where there's a relationship between these entities. Just to give you an example, if you have 50 employees that work in a manufacturing plant, and then you also have a company that has trucks, drivers that deliver the product that you produce in this manufacturing plant, then there's an argument to be made by OSHA or by the investigator or auditor here that would say that if there's common ownership, if these two entities are owned, if these two entities are owned by the same people or substantially the same entities, then these two companies are part of an enterprise, and therefore the 50 employees in one and 50 employees in the other add up to the 100 employees in order to declare this entity eligible for the mandate. So just to keep that in mind. So if you do have a situation like that, you may want to speak to either to counsel. If you have an internal HR or outsourced HR, it's always great to discuss those best practices. If you have those situations where there's a question of whether or not your company or companies together will add up to the 100 employees in order to mandate the vaccine. Thirdly, so how frequently must non-vaccinated employees be tested? It's, as of right now, we're anticipating it's going to be every week. We don't know exactly what that time frame is, but we're we're assuming that the ETS is likely going to follow any CDC guidance. Next slide. Is moving an employee to 100% remote work a viable solution? We've gotten this question under a couple of scenarios. Well, if an employee is working 100% remote and that employee is not entering the facility, it's anticipated that that employee does not have to receive the vaccine. Is not required for that individual to become vaccinated. However, just keep in mind that if you have someone that's working remote, please make sure that that person is working 100% remote. They're not coming into the office occasionally, for meetings, et cetera. If you have an employee in another jurisdiction, let's say another state, and that person's never coming to your office, always working from home, then it's possible that maybe that individual does not have to comply. But that's always something you want to make sure you assess on a case-by-case basis. Do employees on leave need to be vaccinated or tested? We don't have an answer for this as well. However, we do anticipate that similar to the remote work employees, an employee that is on any specific leave where they're not coming to the office while they're on leave will not need to comply with the vaccination mandate or having to be tested. However, again, we're waiting for the ETS to be released in order to hopefully have that answer more definitive. Are employers responsible for administering the tests? There isn't an answer for this in regards to the vaccine mandate. However, we have had guidance in general whether or not employers are responsible for administering the tests, or whether an employer can choose to be responsible for administering the test. An employer can administer tests at its work site. It's not always best practice because in administering tests, you are asking for private information, health information, or PHI or personal health information. And there are extra responsibilities placed on an employer where you're the one actually conducting or administering tests. If you are going to take on the responsibility of administering tests, it's best practice to have a third party that will be administering the tests so that you're not the one actually collecting this data. If, for whatever reason, an employer decides to conduct these tests in the workplace, then keep in mind that that information needs to be stored the same way you would store any other personal health information. And there are very specific requirements of how that information should be stored and who should have access to that information. So again, if you have internal HR, make sure to discuss those requirements which are internal HR. And if you have outsourced HR, please reach out and make sure to just go over your procedures and your policies for administering these tests. Next slide. Will employers be required to offer paid time off for vacation or testing? Excuse me, vaccination or testing? As of right now, what we're aware of is that the employers are not required to offer an additional bucket of time off. They're not creating a new benefit in order to take time off to become vaccinated or to get tested. However, an employer is required to allow the employee to take any time they do have, whether it's PTO, vacation time, possibly sick time, sick leave, in order to get vaccinated or to get tested. So if they have time available to them, the employer is required to allow them to use that time in order to get vaccinated or get tested. But the employer is not required to create a brand new bucket the way we had to do with the CARES Act with the emergency paid sick leave and EFMLEA. That's not what this is doing. It's not creating a new time off benefit. What if an employee can't get vaccinated because of a disability or religious belief? Keep in mind, this is something that employers need to be aware of, that if an employee is seeking a reasonable accommodation because of a disability or because of a sincerely held religious belief, then as employers, we need to engage in what's called the interactive process with the employee to discuss whether or not there is an accommodation that is reasonable that can be made for this individual with regards to vaccination. For example, if someone's job is able to be completed remotely 100% without the individual coming in, and this does not pose what's called an undue hardship to you as an employer, then it's possible that that is an accommodation that is reasonable. Again, this is something that has to be assessed on a case-by-case basis. Some positions will lend themselves to that. Some positions won't. If you have someone working on a production line, that's not really a job, right? That can be done remote. Versus if you have someone that is just working as a receptionist, and he or she can answer phones from home without it interrupting your business or creating any other undue hardship, that may be something you want to consider. But again, that's something to discuss internally with your HR team or with whomever your HR professionals. All right, so those are some of the questions that we've been getting the past couple of weeks. But I think at this time we can open the floor to attendees, see what questions they have. So.
Jose, thank you so much. And we've got some good questions coming through. A couple of things that I think are important that I want to recap. So we're anticipating that they'll use the enterprise rule. So it's not facility based, it's your entire company to get to that percentage.
Right.
And once this rule comes out, we're anticipating that there's going to be some time, maybe around that 75-day time limit for people to at least get the first vaccine, right? So there's going to be some runway for people to adapt to this, right?
That's correct.
Okay. And then something I think is important. So New York State has implemented rules already. So with paid time off, right now, employers are required to offer time off for vaccination and testing. But what we're saying is that we don't anticipate that the new OSHA rule is going to create new time, but it will still allow them they'll still be able to take time that they have or instead of a new bank of time.
Correct. And keep in mind that the states can always provide more rights or benefits than the federal government can. However, it can't be less than what the federal government is, the minimum requirements of the federal government. So if New York State, as we know, does require employers to provide time off, paid time off to get the vaccine, then that's going to trump the fact that the federal vaccine mandate doesn't address that or doesn't create a new bucket. Okay. So just keep that in mind. And in that same vein, just before I forget, obviously everyone's aware at this point of the HERO Act and how as employers with 10 or more employees, how we're required to have a plan in place, and there are a bunch of safety mechanisms we need to have in place, based on the governors declaring COVID a airborne illness. Okay, so it is anticipated that the ETS may contain similar language regarding requiring employers to have some sort of plan. Just keep in mind that plan, whatever is required there, if it goes above and beyond what New York requires as part of the HERO Act, that's something we're going to have to address and maybe, comply with, and we'll have to comply with. But if the New York State HERO Act is more stringent than whatever this plan is that OSHA is going to put in place, then New York HERO Act will trump because it includes more stringent protections for the employees. So I just wanted the membership to keep that in mind.
That's a very important point, especially for this state. So another question we have here, Suzanne poses it. So the employers are responsible for testing. Let's focus on testing first. And as we understand it, there's a financial penalty if employers don't meet the ruling, the ETS, right? So right. How does it work for if an employee gets testing off-site? Are they then responsible, or do we anticipate that then they will be responsible to give that information to the employer, or is there a way for the employer to directly get that testing result from a vendor?
Just giving it some thought here. Just give me a second. First and foremost, whenever a third party can be responsible for conducting the exam, that's always best practice. You know, as the employer, you don't want to be necessarily involved in any sort of testing to the extent you can. The employer can reasonably rely on the employee providing that information with regards to testing. And also in New York in particular, because there are ways of obtaining proof of testing outside of the employer reaching out to a third party, it would be best practice to rely on that information. So for example, if an employee comes in with a negative test and they are using the Excelsior app to show that that test result came back negative, then the less information the employer is obtaining from that individual, better when it comes to any personal health information. But the employer should require the employee to provide proof of those test results.
And so then what would probably make sense then, that the employer needs to keep a very, getting ready for some type of audit or review, keep a detailed log of those weekly test results and what the employee is telling them, right? And keeping documentation of the test results?
Correct.
Yeah.
It's keep documentation of the test results. Some employers prefer to keep an actual copy of the test result itself. Some employers prefer to just keep a log, as you mentioned, indicating when the employee showed proof and maybe describing the type of proof that was provided. Both are reasonable forms of documentation, but it depends on it's an employer decision, business decision, as to how far you want to go in your proof or documentation. Whether you want an actual copy of the result, which may contain information you may not want to have in your records. If you do take that information, you have to make sure you treat it the same way you would any other personal health information, or you can have this log that is tracking what is being provided by the employee. Keep in mind that whomever is obtaining this information should be someone at your organization that normally would have access to this sort of private information, and that is trained on how to handle personal health information.
So staying with testing, a good question from Chris. So again, the employer is responsible for this under the upcoming ETS. Who's responsible for the cost of the testing? Or is that something that's still unclear?
Although it is unclear, what I've spoken to several colleagues, and what we're anticipating, because the nature of this mandate is to push people towards vaccination. Well, what we're anticipating is that the onus of that testing is going to be on the employee, because it's an extra burden, right, as an employee that I'm going to have to take on because I'm choosing to not get the vaccine for whatever that reason is. And so we anticipate that it would fall on the employee just because of what the goal of this mandate is.
Thank you. And so just to reiterate something we've talked about in past events, so under state law, existing state and federal law, the employer does not have liability for any effects of the testing or of the vaccine, correct? I mean, then you brought it up of makes sense for a third party to do it, but this ruling isn't opening New York State employers up to any new liability as far as testing and vaccination, correct?
Not that we're aware of. You know, I never want to, just give me a second. That's something that we're always monitoring. As of right now, so far, it's been in the employer's favor that the effects of the vaccine is not something that would cause liability to the employer. We have seen some arguments being made pre-vaccine mandate, if an employer requires the vaccine, where it's not mandated by any local, state, or federal government, and there are and the person suffers some sort of reaction, that injury, so to speak, may be covered by workers' comp. So we have seen that argument being made. Interestingly, what we anticipate, if it's a mandate by the federal government, whether or not it will be the employer's responsibility. We anticipate, just being that we're in New York, and just speaking realistically, the workers' comp board is always going to try to get coverage for the employee. We would anticipate that if there is some sort of reaction, that may be a covered injury.
Okay, thank you. So another good question here. For contractors, federal contractors specifically, do you anticipate the enterprise rule may apply in terms of the federal contract provision? Is it different? Is it a different location with different EINs? Would that make an impact?
Let's just parse that out a bit. Will the enterprise rule apply for federal contractors? We would anticipate it would. At the very minimum, any location that has a federal contract would definitely be subject to the mandate. If you have certain employees that work in the division that's the only division that does federal work, there may be an argument to be made that it only applies to that division. However, just based again on what the reach of this mandate is purporting to be, we could anticipate that they're going to try to cast as wide of a net as possible whenever they're trying to decipher the definition of some of these terms.
Okay, sticking with the enterprise rule, not with contractors, with the standard business. So if a business is doing work and has facilities in multiple states, but if a state like Florida, for instance, has much different state rules on proof of vaccination, what would be the employer's best reaction to that? Would the ETS then trump the state law in that situation, or can it only collect information that the employees will provide?
Right. No, and that's going to be one of the biggest challenges, is if you do have employees outside of the state of New York, in states like Florida and I believe Montana, where it's unlawful to require to mandate the vaccination. That's going to be it's going to be to how risk averse the business is. Unfortunately, I don't want to give you that answer, but that's really what it is. The states that are challenging the vaccine mandate or quote unquote vaccine passports, as they call them in their states, they have said that any employers that comply with this vaccine mandate will be violating state law. They've been pretty upfront about that. So that's something that the employer is going to have to look at to see what that exposure is in that state, and speak to counsel to make sure that they're making the best decision for them as to which way are they going to turn, left or right, with regards to requiring those vaccines or those employees to be vaccinated in those states. Tangentially related to that, though, an interesting situation that we've come across is where it's not necessarily, for example, your company maybe is not affected by this because you don't have federal contracts, you don't have more than 100 employees, but you service a company that does. So the question becomes, well, if my employees are going into that location for whatever that service are my employees subject to this mandate? So although there's a question as to, it's probably unlikely that your employee will be subject to the mandate directly, because it's based on your business. And if your business doesn't have a federal contract, if your business is less than 100 employees, you shouldn't have to be required to comply with this mandate. However, it's an interesting customer relations issue when your client is probably the one requiring of you to make sure that anyone entering its facilities is vaccinated, right? And so how do you handle that?
That's because Brian has a really good question along those lines. So if you're a company of less than 10 employees, but you have a federal contract, right? Does that mean that by just, even though you're so small, but you have a federal contract, does this then apply to you?
The likelihood is that it will. Again, and the reason why we say that is that we're anticipating that whenever there's a question as to how to interpret this language, right now our default is to anticipate that it's going to be interpreted in a way that casts the widest net in order to have more people vaccinated, since that's the goal of this executive order. So until something comes out specifically addressing some of these issues, we're going to err on the side of that is probably going to, we're probably going to have to take the approach that it's going to require compliance.
And Michaela, I'm hoping that answered your question as well. This is an important one here from Robert, because we're in a region that has many public employees. So we know that this ETS is directed towards the private sector, but do we feel like this will also at some point apply to public employees as well? I mean, we know that there's a provision for federal employees, but do we think that this would then also apply to, say, state employees?
I mean, we end up getting into a constitutional law debate, or whether or not the federal government can mandate the state to do to mandate vaccinations amongst its employees. As of right now, I'm going to err on the side of no. However, what I would say in a state like New York is that, as we've seen, fortunately or unfortunately, the state generally tends to provide more protections than the federal government does, generally. So it wouldn't surprise me, I'm not trying to get anyone nervous here, but it wouldn't surprise me if the state somehow tries to follow suit and do the same. We're already seeing it in certain sectors with healthcare workers, et cetera, where the state is requiring it. So, it wouldn't surprise me, but if that happened, I think it'd be because the state requires it independently, not because the federal government is requiring it to do so.
That's an important point. I think that's why it's important that you talked about at the beginning some of the challenges that might be happening, legal challenges outside of the state, because we should everyone in New York State should obviously continue to monitor and understand the HERO Act and the New York State interim safety guidance, but then understand that this is a federal ETS. So we're just going to have to be mindful of how those two things work together. Follow-up question on going back to contractors. So again, if you're a small company, you have a federal contract, do we anticipate this would only apply to those employees that are going into a site instead of maybe people that are remote or never going onto that federal site? Or do we think that it would be, again, the kind of that enterprise type, everyone is counted? And I know I'm asking, I know that there's a lot of gray area here.
Right.
Trying to get a sense.
I mean, look, the common sense approach is that it should only apply to those that are working on that project or that contract. However, because of the goal of this executive order, I wouldn't be surprised if something like the enterprise rule or that, that mindset that we're going to try, because they want to cast a wider net. So they're going to want it to apply to as many people as possible. So as of right now, until we get further guidance, any question like this where we're kind of on the fence, I would err on the side of we're going to have to comply.
Thank you. And I think that's the best answer that we can give right now, especially looking at the intent of this. Nicole has a good question here. With the upcoming September 30th end to the FFCRA, what are companies doing after this for vaccinated and unvaccinated employees? Because we're going to have we have some gap here, right? Obviously.
Well, we have gotten questions of whether or not we're anticipating the CARES Act will be extended again. We haven't heard anything just yet, so I think we would have heard something by now if it was. What I would just remind everyone is that even though the paid time off that is required by the CARES Act, although those might be going away, let's say, don't forget we're in New York, where the COVID leaves, paid time off for vaccination, these are things that are still going to exist even post CARES Act until the state moves otherwise. So some of the requirements and some of the, from a compliance standpoint, may not look too different come post September 30th, if the CARES Act is no longer required or complying with it is no longer required.
Okay, thank you. And I think really just in closing, what we know we'll have more details when this comes out, but we know that there is a proposed financial penalty for employers if these goals aren't met. So really, at the end of that would be the potential for termination if these employees do not get tested, do not provide proof of testing, and don't get vaccinated. But it's important to note that right now, even before this ETS goes into effect, employers have the ability to terminate employment if vaccination and testing requirements are not met, right?
If they're not met, and if the individual is, if that individual is not eligible for a reasonable accommodation because of disability or a sincerely held religious belief. So assuming that that doesn't apply, then yes, termination is obviously an option, because, and some employers that are welcoming the mandate are actually feeling a little better in the sense that it's they're not the ones making the decision, right? That's what, now it's like, look, this is what the government's requiring. It's not me, it's them. That's kind of what some employers are doing. And it does give you more traction, right? That you make the business case, the argument as to why someone's employment was terminated, why they were separated from the company because of these mandates that are being put in place. And if the person's not eligible for some sort of accommodation, then yes, then termination is obviously the right of the employer.
Right, and along those lines, into one of the questions that just came in, these requirements can be, if you're a company under 100 employees or any company, you can be mandating this already.
Correct.
So if you're a company of 50 employees and you want to have a very clear testing and vaccination policy, you have the legal footing to do it. Something that we would make sure that everyone considers is have a communication plan around that. That this isn't just something that you would put out in a memo. You have to make sure that everyone understands what the requirements are, what weekly testing would look like, and really make sure that they understand what's being asked of them.
Right, and keep in mind, if you're going to have a vaccine mandate, it's related to the HERO Act, right? If that's part of your plan in order to maintain a safe work environment, then that information should be in your plan and communicated with the employees, posted in your handbook, et cetera. So just remember the relationship between the mandates. If you're mandating the vaccine and your requirements, your notice requirements pursuant to the HERO Act, that's goes straight to your point. Not only is it best practice for you to communicate this to your team, it's also required.
Right, and I think as we talked about back in April, employers have a unique opportunity to communicate about this, because as opposed from it coming from a government entity, a CEO or someone in leadership could say, I was vaccinated, here's been my experience, here's why we're implementing testing, vaccination, and social distancing in the workplace. There's it's a special opportunity that maybe the government doesn't have, that employers and leadership have. So a couple more questions here. And this is a good refresher. If an employee is terminated, would they be eligible for unemployment?
You want to give you the law school answer or my cynical answer?
I would start with law school. I would start with law school first.
Generally speaking, if an employer has basically done everything that's required of it under the CDC, state guidelines, requirements to demonstrate that it's a safe work environment, and that individual's reason for not being able to work for your organization is not because of a disability related to getting the vaccine or a sincerely held religious belief, then that person should not be eligible for unemployment. However, in the state of New York, what we've seen is that if it's COVID related, the reason that's given as to why they're not working, unfortunately, we have seen not as much as it maybe 6 months ago, but we have seen the state, unfortunately, be very quick to approve those benefits. And as employers, we got to put in a little extra effort to make sure that they understand the facts surrounding that termination or separation.
Right. I think that's the best answer that we can provide. And then I just want one refresher question that we have here from Brian. We talked a little bit about this in the beginning. We don't know exactly when the ETS is going to be publicized or published. We're expecting though that probably within the next couple of months. Would that be a solid estimate? Then with some, once it's also announced, there would be some lead time for people to adapt to this policy, right?
Yes, not taking into account the potential litigation, the anticipated timeline is that by sometime by mid to end of October, we would have an ETS. And then the 75 days, I believe, would be sometime mid-November, mid to late November, for when employees should have started the vaccination process or have been at least received the first dose, if not both.
Okay. And so what we would say is using that time, companies, especially their HR team, should start to develop a plan for tracking information, understanding what they're going to ask for proper proof of testing or vaccination, to create all of those plans, to have them ready. So this gives us an opportunity, even though we know that there's a lot of gray area, to get your documentation system set up for when the ETS comes out. Jose, before we wrap up, anything else that you want to add?
Just remind everyone that, this is a very fluid situation. Unfortunately, things change rapidly, and, but obviously the partnership does a great job of keeping its membership in the community up to date. And I would just encourage the membership to make sure to utilize your resources to see what's the most current guidance with regards to the vaccine, with regards to testing and anything COVID related, because it is a very dynamic situation.
Thank you, Jose. I really appreciate you being here. I have one more question for you that just came in. So ETSs they're not, people might not be familiar with them, other OSHA ETSs. How often do these happen? And I don't think we know the answer to this, but are they rulings that stay in place for a long period of time, or do we look at this as temporary?
Well, I mean, it's just, they're temporary by definition.
Right.
They don't happen too often. Normally the ETS is put in place until a permanent rule is set. Because of the emergency status, the temporary rule gets put in place. Then the rules as outlined in the ETS are assessed. Constituents are allowed an opportunity to comment. There'll be a committee to review the rules, to review the impact of the rules. And then at some point, there is a permanent rule that is put into place, which sometimes mirrors the ETS, exactly, but a lot of times will have some adjustments to make up for any unanticipated consequences.
Thank you, Jose. Thank you so much again, and thank you to Alcott HR for making you available today. Really appreciate it.
Anytime. We appreciate the partnership with you.
Thank you. Next slide, please. So I want to thank everyone for attending. We also want to just remind everyone to visit thepartnership.org. If you go to our COVID-19 information and resources page, there are templates and information about creating that communication and vaccine and testing plan. I think the main takeaway is that we have some time, but not a lot of time to get ready for this new ETS. And so we hope that everyone takes a look at the resources that are available to you. Thanks again for spending some time with the partnership, and have a great weekend.